Okay, welcome. Another video. This one's going to be on venue, transfer, and forum nonconvenience. Now first, let's talk briefly about what venue is. If subject matter jurisdiction is the determination of whether a federal court has the power to hear a certain kind of case, and personal jurisdiction is the question of whether or not the court has power to force a particular defendant to go there and defend. Well, venue is the question of where within a court system is an appropriate place for trial. And we'll see that under the venue statutes, there can be multiple places where venue is appropriate. So let's start off with section 1391 of the Judicial Code. Okay. The main section we want to look at right now is 1391B. B1, B2, and B3. B1 is looking to where defendants reside. B2 is looking to where stuff happened. And then B3 is looking as a fallback that only kicks in if both B1 and B2 are unsatisfied. Let's look first at B1. B1 says a district is appropriate for venue in any district where any defendant resides, so long as all defendants reside in the same state. So say, for example, let me see if my pen's going to work here and behave. Say we have somebody who is from, Pittsburgh, PA. Oh, looks like the pen's going to be good. Here we go. Evil pen. Ha ha, pen's not going to work. All right, then I'll just say it. Say you have somebody from Pittsburgh, Pennsylvania, sue two defendants. Defendant 1 is from Tallahassee. Defendant 2 is from Miami. Okay? In which judicial districts would venue be appropriate under section B1? And the answer is both the Northern District of Florida and the Southern District of Florida. Why? Well, let's first keep in mind, what is a district? Districts are not states. Some states have one district, like Hawaii. Other states have multiple districts, like Florida, which has the Northern, Middle, and Southern District. Tallahassee is within the Northern District. Miami is within the Southern District. Okay. Well, in this fact pattern, we'll see we have venue in the district where any defendant resides so long as they all reside in the same state. Now, I said the defendants resided in Tallahassee, that's in the Northern District, and in Miami, that's in the Southern District. So the Northern and the Southern are fine. What if the defendants instead resided, one in Tallahassee and the other in Los Angeles, California? Okay? What's that?
Where did the injury occur?
Oh, well, right, you're right, but right now let's just focus on B1. Would B1 provide any venue? So the plaintiff's from Pittsburgh, PA, defendant 1's from Tallahassee, Florida, defendant 2 is from Los Angeles, California. No venues under B1, right? Because all defendants have to reside in the same state. All right. Let's move on now to B2. B2 looks not to where the defendants reside, but instead where property is located or where errors or omissions or acts giving rise to the claim occurred. Okay? So let's take my fact pattern. Let's assume that there was an accident between all the litigants that took place in Orlando, Florida. Now, Orlando is located in the Middle District of Florida. So now we have Pittsburgh plaintiff versus defendants who are residing in Tallahassee and Los Angeles, California, with an accident that occurred in Orlando. We know under B1 there's no district that would be appropriate, right? What about under B2? Which district? What's that?
Would it be the middle district?
That's correct, the Middle District of Florida. That's the district where, as the statute says, a substantial part of the events or omissions giving rise to the claim occurred. So we would have the Middle District of Florida. Now let's combine and toss these hypos around a little bit. let's make the defendants like they originally were. D1, Tallahassee, D2, Miami, accident, Orlando. What districts are appropriate?
Any of the three?
Any of the three. Under B1, the northern and the southern districts would be okay, because all defendants reside in the same state, and one resides in the northern and one resides in the southern district. And then under B2, we could use the middle district of Florida, because that's where the accident happened, right? So in other words, you can have more than one district that is appropriate under the statute. So you think, wow, it's not all that hard to satisfy B1 or B2. Why would you need B3? Well, B3 might arise when the defendants reside in different places, different states, and the events or omissions giving rise to the claim occurred outside the United States. So say, for example, you have your defendants are from Tallahassee in Los Angeles, and there's a bar fight in Tijuana, Mexico. Okay? Bar fights in Tijuana, so you can't use B2, right? Because there's no district of the United States where the claim arose. You can't use B1 because the defendants are residing in different states, so there's no district under B1. So now you can go under B3. If there's no district in which an action may otherwise be brought, in other words, if B1 and B2 are a big fail, then and only then you can go to B3, and then you can have venue in a district where any of the defendants is subject to the court's personal jurisdiction. Okay? And here, where are the defendants from? They reside in Tallahassee and Los Angeles, right? Well, Tallahassee is within the Northern District of Florida. Los Angeles is within the Central District of California. Either one of those venues would be appropriate under B3. B3 is known as a fallback because it is only usable when it's the only basis for venue. You cannot use B3 if either B1 or B2 are satisfied. Now, a couple more complexities about venue. How do you determine residency? Well, residency, here we go, it's working. Residency under C is simply referring to B1 venue. The definition of residency in subsection C just tells you how to determine where somebody resides for purposes of B1. C1 tells you that people reside where they're domiciled. So if you're a U.S. citizen or if you're a foreigner and you reside in any district of the U.S., excuse me, if you're domiciled in any district of the U.S., then you reside in that district. So me, I'm domiciled in southern Florida, so I therefore reside for venue purposes in the Southern District of Florida. Say Daniel Craig moves to Los Angeles, but he's still a British subject. Well, he resides in the Central District of California. Regarding corporations, it's a little bit more complicated. I want to give you the simple version rather than the complex version. For that, you need to look at section C2 and D. Suffice it to say that with corporations, we're treating each district as if it's a separate state, right? So for example, in Florida, we have 3 separate districts. And what we do is ask, would a corporation be subject to PJ within that district if that district were treated as a separate state? If so, then that corporation is resident inside of that state, okay? So say, for example, a Walmart. Walmart's headquarters are in, I think, Bentonville or Fayetteville, Arkansas. I always forget the geography. Is that in the eastern or western part of Arkansas? Does anybody know? Oh, let's just make it up, okay? Let's say it's in the western part of Arkansas. I have no idea. Okay, and I think the districts in Arkansas are eastern and western. Again, I don't remember off the top of my head. Well, whatever district Walmart is got its principal place of business in, that is a place where it's got systematic and continuous contacts. It's generally at home under Daimler, right? So if we treat that district where Walmart's got its principal place of business as if it were a separate state, then for purposes of venue, Walmart is a resident of that state. And then that tells us how to deal with Walmart for purposes of B1. I think for today's purposes, that's enough complexity regarding corporations and residency. And for that, I'm going to stop there. One last thing on the statute I'll note is, what about defendants who are not resident in the United States? So say, for example, you want to sue Johnny Depp, okay? Say you want to sue Johnny Depp for copyright infringement in federal court. Well, which district would have venue over Johnny Depp? Anyone. Because subsection C3 says a defendant not resident in the United States may be sued in any district. Okay? So he can be sued in any district, and therefore it doesn't matter what district you sue him in, at least for purposes of this statute. Now, what if you want to sue Nathenson and Johnny Depp for copyright infringement as co-defendants, right? Depp doesn't live in the United States. Nathenson lives in South Florida. What district would be appropriate? Any district?
Where you are.
That's
Where you're
correct.
resident.
That's correct. Where I'm resident. Why? Well, first of all, it says if Depp was being sued alone, he can be sued in any district. But otherwise, we treat him as being disregarded in determining where the action may be brought for other defendants. So, if it's Depp alone, any district, but if it's Depp plus Nathenson, then we disregard Depp. We look at Nathenson as if he was the only relevant person for venue. Where's Nathenson reside? Southern Florida. Which district? Southern District. So if you want to sue both of us together, go for the Southern District. If you want to sue Depp alone, be my guest, right? All right. That's probably enough on the venue statute. Let's spend just a few minutes on some other topics in venue, removal, and forum nonconvenience. First, here's something that's kind of neat and testable. What if you get asked in the bar exam about what's the proper venue for an action that's removed from state court to federal court? Well, the proper venue for a removed action is not determined by Section 1391. It's determined by Section 1441A, which says venue is appropriate in the district, federal district corresponding to the state court. So if you get a fact pattern asking about venue for a removed case, don't be thinking 1391. Just look to whatever district court corresponds to that state court. Let's see. Here's some other stuff. So you're in federal court. Now the question is venue appropriate? Is it inappropriate? What if you want a change of venue? What if you want forum nonconvenience? So let's talk about all of these very briefly. Suppose venue is valid, okay? Now let's start off with wrong. Venue is invalid. There we go. Wrong venue. So say you want to sue Nathenson for copyright infringement. Say Nathenson infringed your copyright sitting at his desk at St. Thomas University, and Nathenson lives in South Florida, right? Would seem to me that probably that proper venue would be Southern District of Florida. Would you agree? That's my initial assessment based on the limited facts given. But you decide to sue him in the Eastern District of Texas, okay, for some unknown reason. And the court determines, after Nathenson objects, the venue was inappropriate. Well, the court could grant my motion to dismiss. Okay, I would move under Rule 12b-3 for a motion to dismiss, saying the 1391 venue was inappropriate, and under 12b-3 combined with 1406, the court has the power to dismiss the lawsuit. All right. The trouble is the court doesn't have to dismiss the lawsuit. Under 1406, if venue is laying in the wrong district, the court has two options. One is to dismiss. The other is to transfer it to another district where it could have been brought. So, if I make a motion to dismiss for wrong venue, motion to dismiss and wrong venue, this box, the court will either dismiss or it will transfer. What I might do is just move to transfer because of the wrong venue, right? Then the court might grant that instead. What if, however, venue was appropriate, right? Say, for example, there's a couple possible venues. Think of the car accident hypo, right? The defendants lived in Tallahassee and Miami, but the accident was in Orlando, right? Say the lawsuit is filed in Tallahassee. Could you imagine a more inconvenient place for us to have to litigate, right? So say the defendants say, well, you know, venue is appropriate in Tallahassee because all the defendants reside in the same state, and one of them resides in Tallahassee, but we think that's a really inconvenient place to litigate because most of the evidence and most of the witnesses and any police that were there, they're going to be from Orlando, right? So instead of a motion under 1406, we do a motion under section 1404. And here the motion is not because venue was improper, but rather because venue is valid but inconvenient, right? So here we're looking at section 1404A. For the convenience of parties and witnesses in the interest of justice, the court may transfer from one federal district to another federal district, either where it could have been brought, right? So Middle District of Florida, or even to one district or division to which all the parties have consented, okay? So there the court can transfer to a place that it could have been brought, or to some place where it couldn't have been brought, but everybody agrees that it's okay to litigate, all right?
Quick question.
For removal, you need all the defendants need to consent. For nonconvenience, they all have to consent to, or?
I'm sorry?
For removal, all the defendants need to consent.
That's right.
For change of venue, everyone has to consent to, or?
Under 1404, there's two scenarios here. If the court decides to transfer, the one is to some district to which all the parties have consented, right? And that's exactly what you just said. All the parties must consent to it. However, if it's going to be transferred to a district where it could have been brought, then all the parties don't have to consent. And in fact, you can imagine a case where you're the plaintiff and you brought a lawsuit, right? And I'm the defendant, and I'm like, I don't want to litigate in the district. I want to litigate in some other district that's much more convenient for me. And then we're actually litigating the issue of whether or not to grant the convenience transfer under section 1404, right? And here the court would say, well, you know what? This district that Nathenson wants to be in, the defendant wants to be in, is much more convenient, and it's one where it could have been brought, and you, the plaintiff, didn't want to bring it there, right? But the court decides this is a much more convenient place, it's going to transfer it, even though you're actively fighting it. And there, so long as it's a place where the litigation could have been brought under section 1391, then the court can transfer it there even though you object to it. So to answer your question, yes.
But I still have a question about removal. Because you said for removal, you cannot take it out of the state. It has to be removed to a district within the state where it was brought initially.
That's right.
So when you're doing removal, you also need to consider the proper venue now.
But that's a very different thing. What you're describing here is the difference between removal and transfer. Okay, so say you want to be, say it's filed in Dade County Court. But ultimately, the defendants would like to be in California Federal Court. Well, removal can only be to the Southern District of Florida, because under the venue, that's determined by 1441A. Now, if you want to be in a different federal court, you don't use 1441A to get there. Instead, what you would do is a 1404 transfer from one federal district to another.
Okay.
You see, that's removal,
Okay. So
that's transfer. What you can't do is you cannot remove from the Dade County Court to the Central District of California. That would be inappropriate.
Not even if there's consent by all of the parties.
What's that?
Not even if there is consent of all of the parties for the new venue under the venue statute.
That's right. That's right. There's two ways it can go from this district to that district under 1404A. The first is it could have initially been brought there, right? Regardless of an objection from one or more of the parties. The second is that all the parties consent to that transfer. In fact, go back and look at the Piper Aircraft versus Rainio case that you studied in your case books in the first year, right? That case was filed in a California state court, was removed to a California federal court, it was later transferred to a federal court in Pennsylvania, in the Middle District of Pennsylvania. Interestingly, one of the transfers was pursuant to Section 1404, and the other transfer was pursuant to what's called a gold lar transfer that I'm not going to get into right here, but it's akin to a 1406 transfer. Yeah, so that's how you get from one place to another place. Now, being that you asked that question, that cues up the last thing that I want to talk about regarding venue and transfer, which is forum nonconvenience. So using the Piper aircraft case as our paradigm, case is filed in California State Court. It's removed to California Federal Court. Now I'm going to riff on the hypothetical and keep it really simple. Let's assume it was never transferred from the California Federal to a Pennsylvania Federal. Instead, let's assume that after it's removed to the California Federal Court, the defendants say, hey, even though PJ, SMJ, and venue were all appropriate in the California Federal Court, we think that there's another court that's far more convenient in which it should be litigated. And guess where that court is? Scotland. Now let's think about it. In the hypos we just did, we removed from one state court to a federal court and transferred from one federal court to another, right? You can use 1404 to transfer between federal courts, or if venue was lacking, you can use 1406 to transfer between federal courts. The reason you can transfer is we're all one big happy family in the federal courts, right? We're all one court system. You can transfer from one federal court to another because it's the same court system. But what if the far more convenient court is over here in Scotland, right? It's not possible to transfer a case from a U.S. federal court to a Scottish court. There is no legal mechanism that permits that. The only thing that's possible is dismissing the federal litigation with the expectation it will be refiled in Scotland. That's what a forum nonconvenience motion is. It doesn't seek transfer. Instead, it seeks dismissal. So, you see this chart I have up here, it's on two arcs. This is on the website too. Wrong venue or valid venue? Motion to transfer or motion to dismiss? Forum nonconvenience here is when the venue is appropriate, but there's a motion to dismiss. Why? Because there's another court that's far more convenient, but you can't transfer to it. Why? Because it's a whole other court system. And that's what the Piper versus Renyo case is about. Courts look to public interest factors, like the congestion of the court system, the court's knowledge of foreign law, looks to private interest factors, such as the availability of witnesses and proof, the ability to get subpoenas or attendance of witnesses, things like that, and decides whether or not to grant that motion. Something important to remember from the Piper versus Renyo case is the Supreme Court said that it shouldn't normally matter in the forum nonconvenience determination that there's going to be an unfavorable change of law to the plaintiff. You'll recall in the Piper versus Renyo case, the Piper Aircraft versus Renyo case, the reason the case was filed in California courts was because there was favorable American tort law. The victims of an accident were actually Scottish citizens who died in an accident in Scotland, were all Scottish subjects who died in Scotland with English and Scottish companies. And the reason it was filed in California is because the potential tort recovery was much greater. The plaintiff didn't want that forum nonconvenience dismissal to permit refiling in Scotland. Why? Because the case would be worth much less in Scotland. The Supreme Court said, well, too bad. Normally, an unfavorable change of law is not going to be determinative in a forum nonconvenient situation. One last thing worth noting with forum nonconvenience is normally before a court will grant a forum nonconvenience dismissal, before this, say, California federal court dismisses this lawsuit to permit refiling in Scotland, the American court is going to require stipulations of the parties, right? So for example, think of the Piper versus Renew case. It was the defendants who sought that forum nonconvenience dismissal. They wanted to litigate in Scotland, where the law would be much more favorable to them. But what if we go to Scotland and the plaintiffs refile, and now the defendants are all, blah, ha, ha, statute of limitations has expired. Ha, 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 gotcha. Well, the court here in the United States is going to say, hey, if you're going to get this forum nonconvenience dismissal, we may want you to do things like promise not to assert a statute of limitations defense, to permit that lawsuit to be litigated in the foreign court. Okay, let me take a short break here. Let me stop the camera.